Yes, so Varun raised a question. Varun, the thing is that that's enough for you for now. Okay, there are multiple maxims that we discussed during the classes, so I think that should be enough. The maxims taught during the classes, and the 30, 40 maxims that I gave to you in a different section, those are enough. The relevance of maxims is not as much yet, that you go on to study 100 maxims. 30, 40 are enough. We discuss the most relevant maxims. So yes, good morning. Now let's start over again. Good morning everyone, how are you all? Good morning, good morning. Yes, so I'm good. Thank you so much for thank you so much for asking. How are you all? What is happening? First time ever. I don't even I don't even know what YouTube looks like before 3 p.m. and now I get to see it. It's not bad. It's not bad. I'm kind of enjoying it. Kind of enjoying it. Yep. Right. So, shall we begin? Can you just give me Varun? I think I told you. I gave the query to your question. MHCT law 5 years आंसर मगर मार्क्स रिव्यू किया तो उसका फाइनल आंसर या ऑफ कोर्स किया जाएगा डेफिनेटली क्यों नहीं किया जाएगा बिल्कुल किया जाएगा Right, so let us begin now. We have wasted we have spent a lot of time as it is. Let's start. So weekly legal current affairs part 1 August. Mind you, we are going to conduct another current affairs tomorrow also, and it is based on a different pattern altogether. It is based on a legal analysis from the Hindu editorials, right? So when you read a Hindu editorial, you know that it is important. You know it has a legal tone, but what from it is important. How to study that editorial to make it exam relevant is something which is a problem, right? So I am going to bring forth an analysis from Hindu editorials from a legal point of view. Like what Alpa ma'am does is something from an English language point of view, but this is going to be from a legal point of view. We are going to study the legal implications of the entire segment of that editorial. The editorial becomes relevant in what manner is also something that we are going to discuss. I told you that there is a lot of static information that directly relates to the dynamic version of the news. So what static information is related? Everything related to that Hindu editorial, the understanding of it, the legal implications of it, the pros and cons, the author of the opinion of the author, everything will be conducted tomorrow. The time also will be notified to you, but we are going to do a Hindu editorial analysis, legal analysis. Okay, so yes, let us start. Now, Supreme Court to dismiss plea to accept nomination for vice president election. Now, this case law in itself is not as important, but there are some things that you need to remember since this news is now being highlighted or being, discussed, or it is something that Supreme Court has picked up. So there was an amendment, 39th amendment, or before 39th amendment. Wow, Muskan, you are right on spot. That is the editorial that I was going to discuss tomorrow. I am going to discuss the PMLA editorial tomorrow. You are in luck. Spot on. Okay, so now there was a case before 39th amendment which was Indira Gandhi versus Raj Narayan. Right. Now, what exactly happened in this case? Indira Gandhi won the seats or won the constituency of Raebareli. So, every prime minister has to be a member of parliament. That means that he has to win from the particular constituency that he is fighting from. So, Indira Gandhi stood from Raebareli and she won. Her opposition member who was fighting for the same seat was Raj Narayan. Now, Raj Narayan challenged the election of Indira Gandhi. 30 is enough, Varun. 30 is enough. Not more are required. Okay. Now, Raj Narayan challenged Indira Gandhi's election in Allahabad High Court. After examining all the implications of the elections, all the factors, the evidences that were put forth, Allahabad High Court came to a conclusion that Indira Gandhi did not fight fair. Okay, she used malpractices to win the election, and for that reason, Allahabad High Court quashed Indira Gandhi's election and barred her from standing or contesting any electoral position for the period of 6 years. Now, this was the crux of Indira Gandhi versus Raj Narayan. Now, what Indira Gandhi did was she appealed this judgment in the Supreme Court of India. She challenged the judgment of Allahabad High Court in the Supreme Court of in the Supreme Court of India. Now, before this was this was not really the reason for emergency. There were various reasons, right? There were various reasons. Now, before Supreme Court could give any ruling regarding the Allahabad High Court judgment, Indira Gandhi's government or the parliament at that time came up with 39th Amendment Act. And this amendment act was passed overnight, mind you. For example, let's say today morning the Supreme Court is going to conduct the hearing regarding the case, and yesterday night Indira Gandhi, or the parliament rather, brought this amendment and it was issued before Supreme Court could hear anything. Yes, you need to note the relevant stuff, of course, Shruti. Note down the relevant stuff. Right, so before Supreme Court could say anything, Indira Gandhi ji got this amendment passed. Now, this amendment, what did this amendment do? The 39th Amendment very expressly or in clear terms said, yes, you have to make notes. How is that even a question? Of course, you have to make notes. Right, so using 39th Amendment, the Parliament held or made a position that any question relating to the dispute of election of Prime Minister, okay, there was 4 candidates actually. I'll just say instead of writing. So any dispute relating to the election of Prime Minister, Speaker of Lok Sabha, President of India and Vice President of India. So these 4 people, and any dispute relating to their election will not be examined by any court. Okay, so okay, yeah. So any dispute relating to the elections of Prime Minister, Speaker, President and Vice President will not be examined or taken into consideration by judiciary. Now, before Supreme Court could say anything, 39th Amendment got passed and Supreme Court could not give the judgment, could not even hear the matter because 39th Amendment restrained the court from doing so. Since the judgment that was given by Allahabad High Court was pending in the Supreme Court of India, Indira Gandhi could not be moved from her position because the judgment, while in pendency, cannot be executed. right? And before it could be executed, she took away the power of the judiciary to deal with the question in the judgment. That was the smartness. Really, really smart. Now, the only thing that is important with regard to this case law is 39th amendment and few other points. So this question is related to a certain nomination fee for the vice president, right? The name. Yeah, she did. Very, very. I mean, to put it in an appropriate manner, of course, she misused the power. She played extremely smart, right? So, the Supreme Court has rejected a petition filed by Dr. Mandati Tirupati Reddy seeking directions to the Election Commission of India to accept his nomination for the post of Vice President of India. Okay, so that is how it is important. Now let's study a little bit about vice president. These are the qualifications for a person to be appointed as the vice president of India. He or she needs to be the citizen of India, that's prime. He needs to be above 35 years of age. A child cannot be the vice president. He cannot hold any office of profit, which is a qualification for a Rajya Sabha member also and a Lok Sabha member also. Yeah. Office of profit is something that has been interpreted. I cannot share it. I cannot share it. I think the team would. You can talk to the counselors or somebody in the team will help you. They would share the link. They would share the link. If it is released, they would share it. Okay, Sujata? I cannot do it personally. I don't have access actually. Yeah, so they cannot hold any office of profit, which means that they cannot do anything that generates profit to them, right? Apart from being the vice president or the president of India, they can just fit one position. That is important enough. They need to be qualified for the election of member of Rajya Sabha or Council of States. Now, so we haven't launched that, Sujata, but we are going to launch it very soon. Then we shall share it. Okay. Now, there is a speaker of Lok Sabha. There is a person who heads Lok Sabha and he is known as the speaker. There's a chairman who heads Rajya Sabha. So the chairman is headed by the Rajya Sabha is chaired by the chairman. And who is the chairman? Can anybody tell me? Who is the chairman of Rajya Sabha? You should know this, that Chairman of Rajya Sabha is an ex officio post, which means any vice president of India would automatically also become the chairman of Rajya Sabha. Such posts are called ex officio. By virtue of the office you are holding, you get to hold another position also. For example, Prime Minister is the ex officio chairman of Niti Aayog, right? So ex officio vice president. Good. Yes, exactly. Um, the office of the president, Article 63 lays down for the office of vice president, and Article 64 states that the vice president shall be ex officio chairman of the Council of States or Rajya Sabha. It's very important. Don't need to remember the article, but you definitely need to remember this. So you need to remember the name of the chairman who is the vice president. Okay, that's it in this. Let's move on to another news. Now, the case law that we are going to discuss now is Daksaben versus State of Gujarat. Now, there were several points in this case and we shall discuss all of them one by one. I would request you to note these important things. Can you get the PDF after this class? I don't think so. I don't know actually. Maybe. You can take a screenshot, but I don't think you get the PDF. No, there's no option on YouTube. Like on our portal, like BYJU'S portal, we can give you that option, change and mix and match our software to your convenience. But on BYJU'S, on YouTube, we do not get that discretion. Right now, Understand the facts of the case. What exactly happened in this case? There was a man who was actually cheated for a certain amount. That amount was pretty high in itself. Okay. And the man was facing a financial crisis as it is. On top of it, he got cheated. And the cheating affected his mental well-being to a situation that he decided to commit suicide. Okay, he killed himself. Now, there was an FIR that was filed under section 306 of IPC. What exactly is 306 of IPC? Abetment to suicide. What is abetment? Abetment basically is provoking somebody to do a thing. Right, encouraging another person to do something that you want him to do. So that is what abetment is. If you instigate or provoke a person to commit a crime, we call you abetter because you have provoked a commission of a crime. So while that criminal is liable, you are also liable because you have abetted it. Right. Now, there was a problem in holding the constitutional validity of 306. Right. And the problem was that suicide is not a crime anymore and suicide is no longer legal. I think the text is visible and that's enough, right? Can we concentrate on the section right now? Yeah, can we concentrate on the session? Then we'll discuss whatever it is that you want to discuss. Okay. Now, the problem in this case is that, not the problem, but the concept that you need to remember is that the constitution validity of suicide has been challenged time and again. Right. So, in P. Ratinam case, it was held that suicide cannot be a crime. It cannot be a crime because right to life includes right to die. So if a person has a right to spend his life in whatever manner he wants to, that person should be given the choice to end his life whenever he wants to. Because whether or not to continue that life is also something which Article 21 guarantees. Now this was held in P. Ratinam, right? And based on this, another case comes which actually completely overruled this previous case. Now in that case, the problem was that the mother-in-law was implicated or charged under section 306. Can anybody tell me the name of that case? Can anybody tell me the name of that case? It's something versus Punjab. I have told you that one or two times. No? That's your homework. Okay, figure out the name of the case that I'm discussing. Now, in that case, the mother-in-law was charged under section 306 of IPC. Now, the contention, not Menka Gandhi. No, I said state of Punjab. Okay. Now, the contention of the petitioner in the Supreme Court about section 306 is that in P. Ratinam, you have already said that suicide is not a crime because a person has a right to end one's life. So, if my daughter-in-law ended her life and I helped her doing it, even if I helped her doing it, if we are establishing that I might have something to do with it, it means that I helped her exercise her right. Abetment is punishable only when abetment is towards a crime. If I encourage somebody to study, I will not be punished because studying is legal. Right? So unless and until I am abetting something which is illegal, I should not be punished. You've already said that suicide is not crime. So by abetting something which is not criminal, I haven't committed any crime. So I should not be charged. That was the contention in this case. Got it? Supreme Court immediately realized the implications or the aftermath of P. Ratinam, that if we are to allow the removal of section 306 completely, and if we are to allow that suicide or right to life includes right to die, we would actually be given a we would actually be giving a free hand to all those in-laws who are torturing their daughter-in-law and wants them to die, and they will just be moving. Yeah, it is not weird, it actually makes sense. So if you include that right to life includes right to die, you are actually making deaths legal. So if anybody has done or said something which has led another person to take his or her life, they will never be punished, because suicide is evidently not a crime, right? Because anybody who wants to live can also die. Now, based on this, that what uh, tyranny can this judgment can do to all the daughter-in-laws who are being tortured by their in-laws, and the aftermath of everything, the entire object of trying to make the laws strict so that the daughter-in-law or the harshness of domestic violence and dowry demand can be subdued, all that will be for nothing. And that is why they said that right to life does not include right to die, and hence suicide is a crime, and abetment to suicide would also be a crime. That was the case. That was the case, right? Now, in this case, what was happened? This man who died because of cheating, and the cheat was charged under IPC for cheating and under 306, because his acts affected a person in a manner that he took his own life. Now, the other thing or the next event in this case was that both the parties, not both the parties, but the cousin or the cousin of the person who was cheated, or the cousin of the deceased who also worked for the deceased, sort of entered into a settlement with the defendants, that we will remove the case or we'll cancel the case, we'll withdraw the FIR and everything. You give us this amount of money, okay, or you give us back the money that you took from us by cheating, right? And this settlement got finalized. After the settlement got finalized, there was another plea in the Gujarat High Court for the quashing of FIR. Now, you cannot just go to the police station and tell them, sir, I don't want to continue with this case. Can I take my FIR back? It doesn't happen. If you do not want to continue with the case, if you no longer want to continue the case, if you compound the case, right, you have to apply for that in the court. The court will quash the FIR. Then the case is compounded. That is how things work. The court will cancel the FIR. Okay. Now, the problem in this case was that Gujarat High Court quashed the FIR because there was a settlement between the plaintiff and the defendant, and the wife of the defendant, the wife of the plaintiff, the wife of the deceased, actually the person who died, the person who committed suicide, had no say anywhere. Like, she did not agree to the settlement, she did not even want the settlement. It was just the cousin come employee doing the work. He decided that there should be a settlement. He decided that let's take the money and settle the case. And she asked the High Court to recall the judgment of quashing. Why is the High Court quashing this FIR? How can an offence of such... Why are you so worried about... I don't understand what is such problematic when it comes to maxims. I told you there's a very minimal chance of them coming. Okay, it is less than 5%. In CLAT, it might not be there. It has not been asked for 3 years in a row. Might be one question, maximum 2 from any other exam. Just read them over and over again. Don't over stress on topics which are not even important. There are more important things to worry. Okay, so that's okay. Don't fret over the 30 maxims, how to remember. Just keep reading them over and over again, and that should be it. You just need those maxims, and that's just it. If you read them, if you understand the theory behind them, there's no problem reading it, there's no problem remembering it. When you watch a movie, do you have to cram everything from the movie? So if you, let's suppose you go to a theater, watch a movie, and if somebody asks you what was the plot of the movie, won't you be able to tell it without any problem whatsoever? Why? Because you have watched that movie, you've understood that movie. That's how law also works. Understand it like a story, understand the philosophy, the theory behind it, and you are good to go. You won't forget anything. You don't have to cram anything. Okay, do not overemphasize on maxims. The cost efficiency or the cost benefit for maxims is too less to worry about. Okay. Now, where was I? Yep. So the wife actually appealed the High Court to reconsider this. Why has it quashed the FIR, and does it even have the power to quash an FIR for such a heinous offense? And this question was challenged or appealed. This quashing was challenged in the Supreme Court. Now, the quashing, give me some time. Now, the quashing is not really laid down. What gives any court the power to quash an FIR? This is not really given in the Criminal Procedure Code, not given in the Constitution, but we have another section which is called section 482 of CRPC, something we discussed in the last class also. Now, this section 482 of the CRPC, yep. Good morning. So, section 482 of CRPC actually empowers the High Court to do everything that is not expressly given in the Criminal Procedure Code. Right? So, according to any problem or the dispute or the grievance that has been addressed, not everything can be listed down. A code has to be exhaustive, like it has to come to an end. You cannot add innumerable sections just for the sake of it. Oh my god, this can happen, this can happen. If you start predicting, the code will never end, the procedure will never end. So that is why they actually incorporated one section. So whatever is not there in whatever is not there in the Criminal Procedure Code but is demanded, okay, there is a power which is demanded of the High Court in order to do complete justice, but that power is not really listed in the Criminal Procedure Code. So in that situation, what does a High Court do? It taps into section 482, invokes section 482 and does what is required even when there is no provision for it. Got it? So for High Court, the section is section 482 CRPC. For Supreme Court, it is an article which is called Article 141. Okay? Everyone clear? Is there any doubt whatsoever? So, yeah, CLAT user student. So, I actually will conduct a whole session on it as to how you can make notes. Right, because it's actually a lengthy discussion which cannot happen here. Right now, whatever I'm speaking, there are certain things that I speak. Why don't you just write them down? That is also fine. Okay? Yeah. Got it? Now, the Supreme Court, every concept is clear. Like we have discussed a lot of laws. Okay, so I hope that you wrote them. Now, the Supreme Court in this case said that when you are quashing an FIR, you need to see if the quashing of FIR is not resulting in injustice. Section 482 is given to the High Court to do complete justice. But if you use that section to give a justice which is half-baked, which is ill-conceived, which is done after not considering every aspect of the case, then you are not using your powers right. If you are quashing the FIR on an appeal by the cousin who was the employee of the deceased, then you are not taking the interest of the direct relatives of the deceased, which would be his wife and his children. So without considering or without taking into account the interest of his wife and children, you decide to do something, or you decide to listen to a far-fetched relative because he has said that there is a settlement, and you just ended the case. It is not right. Let the judgment be pending. Let the judgment carry on, but at the cost of affecting the justice or the justice delivery, do not just end the judgment or do not cancel the judgment. If it continues for a long time, let it continue. But that long time should ensure delivery. You end it in a short period without delivering justice, there is no point of it. Okay, it was also held that section 306 is a heinous offense. Somebody affecting somebody in a manner that that person decides to take his life cannot be taken lightly. This is one offense that should not be compounded so easily. This is one offense whose FIR cannot be just quashed like that. Listen to the parties, examine the situation. How affecting that instance would have been that the person decided to commit suicide. Do not take it lightly, and before compounding the offense, take every factor into consideration. Before that, you cannot use this power. Offense compound means you can settle it. Okay, you can compound it. You both parties, the defendant and the plaintiff, can enter into a settlement. I'll cancel the FIR. You give me this much money. That is what some kind of settlement is. Okay. Yep. Now, this section 482 is based on these following maxims. Okay, the principle of natural justice. Like I said, that the power to the High Court is given and the power of similar nature is given to the Supreme Court. All the best. Okay, Khushi, we'll think about it. We'll think about it. Okay, yeah. So, natural justice. Now, the power is given to the High Court and Supreme Court both in CRPC and the Constitution of India, and it is given so that the justice delivery system does complete justice. Okay, so that they are not hampered or interfered or constrained by the clutches of law. They should be free in their respective spheres to do whatever it is that is required to do complete justice. This kind of justice is called natural justice. Okay, so natural justice, there are three principles that recognizes it. Nemo debet ex judex in proporia causa, the first one. The second is odi alteram partem. The third is the speaking order. Now I'll tell you one, the next is the other two is your homework. Speaking order means a judgment which has the reason, which speaks. Okay, so whenever a judgment comes out, whichever courts is imparting the judgment, they have to make sure that the judgment comes out with appropriate reasoning. Why have we decided what we decided? What did we consider? What are the evidences? What did we think about the evidences? What logical conclusion do we draw from the evidences? Why are we favoring this party? Why are we not favoring this party? Why are we sending this person to jail? So every question that is there in the judgment has to be answered by the justices, and this kind of judgment or these kinds of orders are called speaking orders. Orders with reason. Why have you done what you did? Okay. Now these two, the first two, nemo debet essex judex in propria causa and odi alteram partem. This is your homework. You need to do them on your own. Okay. Yep. Moving on. Now, abatement of, I told you why cannot be, why it shouldn't be quashed, right? Another thing, if abatement to suicide has led to crimes such as, if there has been abatement of crimes like murder, rape, burglary, which is robbery, dacoity, or suicide, they are the crimes against society. They hamper the society, the well-being of the society. Many people get affected, and they cannot be just taken lightly. So if you are the abatement, or the abatement to suicide cannot be taken that lightly. It is important that everything is given due consideration. Yes, Tuti. Um, I teach mostly all the batches. Okay. Now, so this is another. These are the another provisions which are actually created in such favor. Like, apart from Section 306, any crime is actually which can be compounded, where the people can take the money and compound the offense, where the plaintiff would be more than happy to receive the money from defendant and withdraw the case. But again, there has to be consideration, because these crimes are not individual crimes. Crimes are majorly never individual, they affect everyone. So if you are forgiving somebody, that means that the other person would have a leeway to do it. Like, they would always expect, oh, this is so easy, just give the money and they would withdraw the case. There would be no fear instilled in the society anymore. Everybody would pay the money and just get away with whatever they did. So you cannot just compound anything like that. The similar provisions that should be considered a lot, like too many times before a court decides to compound them, are 498A and Section 304B. They are as important, and they cannot be just compounded like that. 498A is related to cruelty, right? And 304B is related to dowry death, something that we discussed in the last section. These are the landmark judgments in M. Mohan versus State, and Gurcharan Singh versus State of Punjab. We discussed section 306 when we were discussing this entire news. Like, I have already discussed it in good detail. Okay. Now, what exactly section 304 498A? Section 498A is cruelty. It is abetment to suicide. Yes, abetment to suicide. Okay. Now, Section 498A deals with the husband or the relative of the husband subjecting the woman to cruelty. So, she can complain about that cruelty, and that cruelty is not necessarily dowry specific. It can be cruelty of any nature which can be complained against, right? So, this offense is also compounding. Yes, you need to cover current affairs from the month of January. That would be a right approach, safe approach. So yeah, where was I? So the lady who was being subjected to the torture can lodge an FIR under section 498A, and the people involved would get an imprisonment which may extend up to 3 years, and they're also liable to fine. This is 498A. Another section which cannot be just compounded like that is section 304B, which is dowry death. So if a woman dies under suspicious circumstances, like she does not die a natural death within 7 years of marriage, and it is shown that soon before her death she was subjected to harassment related to dowry, so in this offense it will be assumed that the death was caused by her relatives, and this kind of death is called dowry death. Okay, so now both these offenses, dowry death and cruelty, uh, laid down under section 498A, are compoundable, but again, like section 306, the Supreme Court. Why am I looking black and white? I'm not sure. The camera is not that great. So I'm taking my classes from my hometown because I'm not well. So I might look black and white for a while. Okay, I'll return to color, but that would take time. Yep. So these offences are compoundable by nature. Section 300 of IPC lays down not 300, 320 of IPC lays down an entire list of all the offences that can be compounded. But despite the fact that they are compoundable, it has to be taken into consideration that these offences are absolutely heinous. They affect the society. They have created a menace in the society. Criminals cannot be allowed to go free just because the offense is compoundable. Okay. So that was the verdict of the case. That's it. That's all you need to know. Now this is again very interesting judgment. What happened in this case was that a person was convicted to death in a POCSO trial by Patna High Court. Nitin, yes, you can complain if it has been taken from your room. It must be somebody who knows you. You can definitely file an FIR. Famous case for 304B, landmark case of 304B. Yes, there is a landmark case. It's not striking me right now, but I'll tell you the name if it comes to me. It's not. So sorry. It's not coming to me. Yes. So now what happened in this case was the session judge actually convicted a person under POCSO Act. What is POCSO? Protection of Children from Sexual Offences. Okay. And he gave him death sentence within 4 days of trial. So the trial continued only for 4 days and the person was convicted to death. Yeah. Thank you so much, buddy. I hope I get well soon. Yeah. Thank you so much. Thank you so much. Right. So what did I tell you? The trial. You know what a trial is, right? The entire process of acquittal and conviction. Giving of punishment, etc. So the entire trial only continued for 4 days. Generally, trials are lengthy, but this trial continued for 4 days, and within 4 days, the person was convicted to death. Now, the problem that was expressed in this case by the Supreme Court was that if you are scared about the pendency of the case, that's another issue. But putting a person on a death row in a matter of 4 days is unhealthy and can you read it on your own? That's true. Everyone is indeed falling sick. What can we do? Did you read? So you need to know a little bit about POCSO. The full form of POCSO is the Prevention of Children from Sexual Offences. The POCSO bill was passed in the year 2011 and it became an act in 2012, and this actually protects the children from every kind of sexual abuse. Okay, children. And that's it for today, guys. Thank you so much for being so uh, considerate about my health and my coughing, and it really means a lot. It means a lot when the children you are teaching actually worry about you. So no, I'm actually done. I have completed the lecture. Don't worry. Okay. So mind you, tomorrow is one of a kind lecture. I don't think it has ever been done before. So we are going to discuss the Hindu editorial, but we are going to do a legal analysis. So tomorrow's editorial is PMLA, the Supreme Court verdict on PMLA, Prevention of Money Laundering Act. Right? So that's a very, very important judgment. It holds a lot of things, a lot of concepts regarding money laundering, enforcement directorate, everyone. So this article or the editorial was in Hindu. We would be discussing the entire editorial, analyzing it, the laws related to it, the questions, the issue of the case, and everything. Right? So this editorial legal analysis of the Hindu, we would be taking three sources: the Hindu, Indian Express, and Frontline. These are the major sources from where you get the articles in your exam or the passages in your exam. So we would be discussing one or two editorials every Saturday. Okay, every Saturday. Do not fail to miss the session. Do not miss the session. That's it. Just it's very, very important. Analyzing an editorial from a legal point of view is difficult. I would be doing it for you, so I would be waiting for you. The time is not yet specified, but you would get the notification very soon. It would be conducted tomorrow. Till then, everybody, please take care. I shall see you tomorrow. Apna khayal rakhein. It's very easy to fall sick these days. Don't be careless like I was. Right? Keep the studies going. All the best. Thank you. Bye-bye. And also, like the session, share the session, and subscribe to our channel if you haven't already. Okay?